Good afternoon, everyone, and thank you so much for being here and being part of this panel today. First things first, for those of you who don't know me, my name is Adriana Schnieder. I'm a lawyer. I'm also the founder of Digitus Legal, a data protection consultancy based in Madrid. I am also part of the CPDP panel coordinators team. So thank you so much for CPDP as well for enabling these kind of spaces where we can have meaningful conversations. Today, I am honored to be moderating this panel on a topic that is becoming critical and complex as well. How do we meaningfully connect personal data, artificial intelligence, and digital public infrastructures in a way that respects rights, drives innovation, but also that works across jurisdictions? The formal title of this panel is More Than Buzzwords, the vital connection between personal data, artificial intelligence, and digital public infrastructures. And that's exactly our goal today, to move beyond the high-level narratives and explore the actual tensions, the structures and opportunities that are emerging from the intersection of these critical domains. In 2024, AI governance dominated the global agenda, but it didn't stand alone. Actually, digital public infrastructure, or DPI, also gained a lot of traction. The topic has been discussed from the G20 to United Nations forums and also national debates. Often, personal data sits right at the center, either as a fuel for innovation or as something that demands limits and legal safeguards. In this panel, we will explore a holistic take on the subject, and to achieve this, I am joined by three and one online, excellent speakers who bring expertise and a range of perspectives on international governance, digital rights, and emerging technologies. I will now introduce them briefly. So, first, beside me, we have Mr. Bruno Bioni. He's the founding director of Data Privacy Brazil and a professor at ESPM and IDP Sao Paulo. He holds a PhD in commercial law and serves on Brazil's National Data Protection Council and has extensive academic and policy experience in data protection and digital governance. Then we are also joined by Mrs. Carmen Alvarez Valdez. She's a senior corporate counsel at Microsoft's Office Data Protection. She leads engagements with regulators on data protection and tech policy. She brings deep expertise from the AI and telecommunications sectors and holds international certifications on AI and data protection. Moving on, we also have the participation of Mr. Adeboye Adegoke. He's a principal at Luminate and a key voice on internet governance and digital rights in Africa. He led advocacy for Nigeria's Digital Rights and Freedom Bill and brings extensive civil society experience in legislative engagement and regional policy. Last but not least, we have the online presence of Dr. Alison Gilwald. She's the Executive Director of Research ICT Africa and an adjunct professor at the University of Cape Town. As a global expert in digital governance, she advises international bodies like the African Union, the United Nations, and G20 on data justice, AI, and digital inclusion. So as you can see, we have a 5-star panel. And without further ado, we'll begin with the discussion, which will consist of 2 rounds of questions for the speakers, and then at the end, we will also leave some time for engagement with the audience. So to start the first round of questions, I'd like to turn first to you, Mr. Bioni. So Bruno, you have extensive experience and you've helped shape landmark legal frameworks like Brazil's LGPD and current AI proposals. In your view, what are the main challenges in effectively integrating data protection principles into digital public infrastructures, especially in the face of the rapid technological transformation?
Thank you, Adriana. So, good afternoon, everyone. Thank you so much for coming, for showing up. I know that's the last day of the conference. You must be exhausted. So, on behalf of Data Privacy Brazil, I'd like to thank you for your presence. I think it's the 5th consecutive time that we are organizing a panel here at CPDP. and always trying to frame a conversation on equal food between global north and global south, and also in a multi-stakeholder format that matters. So with regards to your question, I think it's really good back to the basics, and also consider the narratives and how the policy language has been framed over the last 3 years at least. We have seen how the global hype around the AI has distracted a little bit from critical discussions around data governance. So I think this is quite problematic because AI and other emerging technologies doesn't exist in a vacuum. So they are built on data. Data is the constitutive element, all of them. And while computational power is quite important to be discussed, it's also quite important to be combined with a discussion with regards data power. And we could see how much this was pretty much energized here at CPDP. It's important to keep that kind of venues in which data is the core element of our conversations. And without strong frameworks related to data governance, I think countries in the global south, particularly Brazil, countries in Africa and others, will remain consumers of technology, or even worse, just data providers reinforcing partners in terms of economic colonialism. And that's why I think two recent multilateral developments are particularly important, and I'm glad that I'm here side by side Dr. Allison and also Adeboye, because we have been collaborating in that kind of developments. The first one that I'd like to highlight, and that's important to keep monitor, is the G20 process. The recent South-South troika of G20 coming from Indonesia, India, Brazil, and now South Africa has helped to elevate the importance of data governance alongside AI. We could see how during the last year, during the Brazilian presidency, the leaders' final declaration explicitly recognized this intersection, and now South Africa has just taken this further with a specific task force by combining artificial intelligence and data governance. And this call to action was also highlighted by a joint declaration coming from T20, the think tank engagement group, W20, human and girls engagement group, Labor 20, C20, so a lot of voices coming together to emphasize the importance of combined data governance discussions along AI and digital public infrastructures. And the second one that I would like to highlight, at least from this policy perspective, is the UN, the Global Digital Compact, the first multilateral digital agreement under the UN. We could see how data governance was completely missed in the beginning of the text, and then became a priority when the text was released, and also side by side digital public infrastructures and artificial intelligence. So to summarize this first round, I think we have been getting some progress by bridging data governance into global AI conversations, especially through G20 and the United Nations, but we are still struggling to fully integrate those three important pieces, and that matters a lot because the grammar of data governance is essential to advancing a grammar of rights, ensuring people and communities that can meaningfully influence how technologies affect them. And if you could somehow play with the title of our panel, we must integrate data governance as another buzzword side by side AI and digital public infrastructure. Otherwise, we are going to embrace narratives of the regulation and also risk-based approach and safety products that are narrowing the rights-based approach here, even in Europe, that we could hear from the panels and the news recently released in that matter. So I think for the first round, I'd like to share this policy overview coming from multilateral process that is important to keep monitoring, and also somehow celebrate the importance of this integration of these three important pieces data governance, digital public infrastructure, and artificial intelligence. Thank you.
Thank you very much, Bruno. Thank you for sharing these challenges with us, and it's good to know that there's been efforts internationally to tackle these topics, of course. Let's now bring in a global industry perspective, and I will turn now to Carmen. Carmen, working at Microsoft, you've seen how digital infrastructures roll out across different regions. What would you say are some of the best practices to ensure that digital public infrastructures are implemented across different jurisdictions, comply with various data protection regimes, such as the GDPR and local legislation?
Yes, well, thank you. Also, thank you to Data Privacy Brazil for the invitation and to the audience. In terms of best data practices, since, as Bruno was explaining, a lot is about data, the data of citizens that will benefit from these digital public infrastructures and in using essential society services. So a lot of the best practices that I can mention touch data protection practices. So first of all is understanding and mapping the regulatory requirements. So you have to understand what would be under these national data protection laws, whether GDPR or LGPD or POPI in South Africa, whatever, what requirements, and especially because it's about citizens concerning consent requirements, data subject rights, purpose limitation, minimization principles, etc. Well, then to continuous monitoring these developments, and then whether any law is enacted, a new law or amended, so amend these policies and practices. Second practice is implementing a robust data governance frameworks, something like the principles-based framework, which is the United Nations Universal DPI safeguards framework, which touches human rights, inclusion, privacy and security is an excellent one, and also embed privacy and data protection principles into the design of the platform and infrastructure, because it's important that you build them from the outset, right? Another practice is the adoption of international standards and best practices. So having the use of open standards and APIs, which will benefit the interoperability between these systems and also in between jurisdictions, that will also facilitate not only the compliance, but also scalability. Within that is also important to respect any data sovereignty requirements, which, well, understanding sovereignty as complying with the data protection requirements wherever you will have your data stored. And within these sovereignty requirements may also include any data localization requirements. Then important, the collaboration with the stakeholders, academia, governments, industry, civil organizations, because these DPIs have to be inclusive. So that requires, well, this involvement. Investing in training and capacity building so that people understand how to use these infrastructures. And, well, then the transparency and accountability. So to develop clear data protection policies, how you use, how you collect, how you store, how you delete the personal data, and other accountability measures, like, for example, the appointment of a DPO, data protection officer, or then like audits, audits reviews. And, well, to finalize, leverage the technology for compliance. So to put, automate processes, streamline them as well, so to ensure not only compliance, but also be more efficient and ensure that there's compliance globally. And then use advanced security technology to protect that data by having access controls user, all that. Okay.
Perfect. Thank you very much, Carmen. So you've talked about the importance of principles and to incorporate them into the regulations. Also, you've talked about cooperation between stakeholders, the importance of training, and the investment. So now let's build on that international element as well that we are discussing. And Adeboye, based on your experience coordinating international forums on AI governance, can you tell us how can principles of transparency and accountability be effectively incorporated into digital public infrastructures to ensure the protection of citizens' rights?
All right, thank you. I guess I'll start by, and I seek your indulgence to start by acknowledging my affiliation, which is Luminate. And they pay my way to be here, so it's important that I pay some bills as well. So just to introduce to you that I work for an organization called Luminate, and Luminate is a global foundation. We work to ensure that everyone, especially those that are underrepresented, have the information, the power to influence decisions that affect their lives. So we are working at the intersection of technology, human rights, and social justice. We support people, organizations, and movements working towards a future that where technology serves their interests, their rights, and does not undermine them. Although we focus on marginalized groups in the global south, largely in Africa, Asia, and Latin America, because of the role that European tech regulation plays in shaping what happens elsewhere in the world, we also pay attention to what happens in Europe. So in case you are wondering what I'm doing in the room, that's why I'm in the room. So to go to your question, yeah, it's really interesting to look at the challenges around transparency and accountability when it comes to digital public infrastructure vis-a-vis citizens' rights, because sometimes it's difficult to make the case, a compelling case on why these two essential elements are important in DPI's conversation. But I think the first way that I would like to address this is to say that it's very important that we have transparency in digital public infrastructure, because open design and public consultation saves us a lot of headache. And I'll give you clear examples. I'm a practitioner as well. What I didn't mention was that before I joined Luminate, I spent 10 years in the civil society space, advocating for the rights of citizens in the context of technology. And some of the issues that we have always emphasized is the importance of open consultation around the development and adoption of technology, such as DPIs. So open consultation allows multiple voices to be heard, and also allows us to pay attention to areas that might not be considered very important by, say, government and the private sector, because government and private sector usually lead this conversation for obvious reasons. Government because they have the regulatory authority, private sector because they have the financial muscle to probably support the process or to create business and galvanize the economy. But in most of those conversations, other voices such as civil society organizations are hardly brought into the conversation. The same with marginalized groups, persons with disabilities, people living in rural areas, etc. So this open consultation provides an opportunity to integrate those voices into the conversation and ensure that technology at the end of the day serves the interest of this community. So in this context, in the context of transparency in digital public infrastructure, when you have open design and public consultation, it helps a co-design of infrastructure with different stakeholders that I've mentioned, which include publishing algorithm decision-making criteria such as data sources and oversight mechanism. Secondly, accountability. Accountability has to be embedded both structurally and procedurally. This means that the establishment of independent oversight, for example, embedding redress mechanisms, and so that citizens can have clear, accessible channels to challenge decision or, report abuses. I think the third point I'd like to make is that we must also adopt like a right-based frameworks in the deployment of digital ID system, which is very critical to DPIs, biometric databases or any power public services. So I'll give you an example from Nigeria, where I live, where digital IDs were rolled out without adequate safeguards. This is what happened. At some point, vendors, third-party vendors, started to hawk citizens' data on the internet. So you literally can go online and say, I want to buy the data of this person. I want to know their home address. I want to know their, personal information, and I pay a fee. There was an investigation that one of our partners, Illuminate, did, whereby you could access the data of just anybody by paying $1. Less than $1, actually, right? Equivalence of about half $1 to access this. And here, how did we arrive at that point? We arrived at that point because the Digital Identity Management Commission had licensed some third-party vendors to provide digital identity services for identity verification. But there was no strong regulatory oversight over them in terms of what they can do with the assets that they have. So the guys who wanted to make money thought, if a lot of people are not coming for identification verification service, we can probably sell some of this data. And so they started announcing to sell those data, and people were coming to buy and pay less significant amount of money. So the point really here is that this type of consultation allows us to fix some of these gaps, because what it does is, where there is no confidence in the data governance ecosystem, then by effect, you also don't have trust in the digital economy, which then exclude a lot of people from participating generally in the digital economy. And I think lastly, before I yield the microphone, I think we have to also look at international collaboration can play. I did mention the role that EU tech regulation, for example, have in other parts of the world. If you look at the data governance regulation in Africa, in Asia, or elsewhere in the world, you would see the huge influence that the EU ecosystem has in all of those spaces. So I think this type of collaboration has to be encouraged, not just in terms of waiting for the EU to come up with a regulation and then adopting it or copy-pasting it, but in terms of being part of the process, being part of the conversation, being able to adapt that to what obtains locally or what obtains contextually, whether in LATAM or in Asia or in Africa. So collaboration is very powerful, and I do think that having the EU, the African Union, and the equivalent in LATAM, work more collaboratively together creates an opportunity to mainstream the advantage of DPIs in different contexts of the world. Thank you.
Thank you very much. So practically, you've said that there's a need for public consultation where all stakeholders can be part of the dialogue without excluding minorities. That's a very important point. Then also you've addressed the necessity to have accountability and to have redress mechanisms, and hopefully all this will help building trust, which is a key note in this. And lastly, the importance of international cooperation as well. Now I would like to have the participation of our online speaker, Dr. Gilwald. I don't know if she's... Hello. Yes. Thank you very much. So Dr. Gilwald, you've led major research projects across Africa on digital equity. From your perspective, how can solid empirical research actually guide the development of digital infrastructures that drive economic inclusion and innovation and protect fundamental rights in a very diverse context?
Thank you very much. And I will speak from an African perspective, with a caveat that we're talking about 50 different countries with very different political economies and development and various things that are very important contexts to understanding these issues of digital and data inequality. But just linking them to the theme of buzzwords and DPI and AI, which of course are the prominent items on the multilateral, donor, and our national government, regional governments agendas. And I suppose the important point I wanted to say is that while there is enormous potential that we can see in DPIs, and of course with the application of and deployment of AI under the right conditions, as things currently stand in terms of digital inequality, and I'll speak about that a little more nuanced in a way, it is simply impossible to make these digital public infrastructure systems equitable currently, and it's simply impossible to conduct ethical, unbiased, whatever, AI while we have closer to half than the more conservative sort of third of the world's population that are certainly not meaningfully online, and many of those not connected at all. And in the African continent, this is well over half of the continent, more like 65% of people that are not even online. So the importance of these technologies and the ecosystems that surround them in solving many of these problems is that they, there are certain assumptions around certain things that exist there. And that's why the empirical evidence is so important. And this is a very basic level. I'll give you an example. So the focus in terms of digital inclusion, which is obviously the underpinnings of the G20 work on this, the Global Digital Compacts, prefaces DPIs and AI with the importance of this, and of course of the need for data for it, is that there is very little data, and the empirical evidence that I'm going to provide is very patchy across the continent and needs to be done far more substantively. But the chasing of these new technologies and these new technology fixes does mean that there's been a complete diversion of funding of the agenda of the development of the quality of research and the empirical innovation that we need in order to get data under very difficult circumstances and be able to apply it to policy. So I think that's just an important caveat to the buzzword conversation, or is that these until we address the underlying digital inequalities, we will be unable to ensure that these DPIs are transformative, or that there's AI that can be deployed, that you can honestly say can be deployed, that has data sets that can be unbiased, because there simply isn't the data. And so certainly in the big social networking data sets that that the bulk of these large language models, etc., and foundational models are built from, there simply isn't the representation of many of the world's population. Half of Africa, more than half of Africa, is simply invisible, underrepresented, or discriminated in these systems that are now being layered over the existing inequalities that we have. So I think an important part of discussing these DPIs, because I do think they have enormous potential under the right conditions, I should add, but the caveats really are about the necessary institutional arrangements and the necessary governance arrangements in order to, and that you need evidence for, in order to ensure their implementation. A lot of the DPI language, a lot of the DPI policy looks at the sort of top end of the stack, or it looks at the DPI stack and it assumes some of these foundational infrastructures are there. So, in your standard, DPI thing, there's often reference to financial digital payment systems, to digital ID, and to data exchange, but very often not to the foundational broadband infrastructure on which this all stands, and which, of course, is very limited in various many parts of the world. So we haven't even don't have the digital or biometric stuff. Never mind the integrated digital payment systems, because we don't even have some of this foundational infrastructure. But importantly, the infrastructure is not simply the supply side, networks that are there, because in many parts of Africa, for example, we have 95% coverage, and yet we only have these, in many least developed countries, less than 20%, 15-20%, the minimal critical mass that we know needs to be there for these positive network effects that produce economic growth and those sorts of things. So I would just say one of the problems with DPIs, as presented by many of the multilateral governance frameworks and of the bank frameworks and these kinds of things, is that they work from a position where you have institutions that can implement safeguards, that you have economic policy that will be able to drive the conditions in order to see those benefits and to see the benefits of DPI or AI application, whatever it is, for all. And so if you'll just cut me short when my minute's up, because I've lost track of when I started, but just to say one or two more things about this. So I think one of the important things for us to do in terms of cutting through the buzz is to just, in the first instance, just challenge this notion that DPIs are inherently good, because I think they have the potential to be good, but I think we need to really understand under what conditions that they will produce these goods. There's a lot of technological determinism. If we get the stack right, if we get this right, if we get that right, it's going to be solved, even if we get those infrastructures in place, which are an important economic underpinning of this. There are a range of other factors. And then, of course, a lot of the DPI is being sold to governments at the moment in terms of very kind of narrow efficiency and productivity gains. And of course, these are absolutely critical. But they are certainly not the maximizing of value, and they on their own don't necessarily meet broader public interest goals. So I think what is very interesting at the moment is the work that is trying to inform policy on the basis of economic and social evidence that, and theorizing anyway, that you get much greater value from short-term kind of efficiency applications. You get much greater value if you are trying to set the DPIs up within a public value framework. So you're actually looking at the benefits of, say, a sectoral DPI, not narrowly in terms of getting data moving more efficiently through the system and everybody being on a shared system, but that you are enhancing public health, and therefore the social value of the DPI is potentially much greater. And of course, improving social health, you've got multipliers for other parts of the economy and society. So I think my time's probably up, and hopefully in the next round we can speak about some of the solutions, because I think on the continent there are a number of integrated governance frameworks that are there at the moment, and regional opportunities that allow us to address some of these problems. Thank you.
Thank you very much, Dr. Gilwold, for those very rich insights. I will now move into the second round of questions, where we will look more closely at mechanisms of accountability, cooperation across sectors, and inclusion. So once again, Bruno, I will turn to you. You have talked to us already about challenges, but now let's talk about accountability. So from your perspective, how can the accountability approach be practically applied to ensure that digital public infrastructures respect data subjects' rights, promoting transparency and responsibility in the use of emerging technologies?
Thank you, Adriana. Can you hear me? Yeah. Okay. So I think, first of all, it's important to take a step back and try to grasp a concept of what it means accountability. Accountability is a notion that someone is handling an account and is considering to be accountable. So it's like a kind of a relational ship concept. So I think that's quite important, because then we can frame how data protection is also important to consider automated decision making, and how DPIs also fit in the conversation. So for instance, we are paying too much attention and putting too much energy to discuss what kind of lawful grounds and our legal base would be better or would be fitted in a way to train AI models such as consent, legitimate interest, and so forth. But I would say that principles such as transparency, principles such as data quality, and mainly the effective exercise of data rights would be one of the better tools that we have right now, even before AI acts over the world, but data protection laws, in order to make those systems accountable. So think about the issue and the role being played by data quality. The whole discussion about bias, discrimination, furthering discrimination, automated discrimination, is about how those data sets are not representativeness. And this is an obligation of a result, not an obligation of means, which means that we can have like a more substantive protection for data subjects and also citizenships. The second issue, when we think about the right of explanation, but also the right of reviewing an automated decision. This is quite important because right now, at least in Global South, when we are thinking about automated decision-making by public policies, social assistance, and so forth, the reality is that the people on the ground, they are not even aware about those automated decision-making. So it's an issue of informational due process as well. So how people are being affected, but how they are being aware of it and how they can contest those information flow. So by combining those principles, but also those kind of data rights, I think we can not only issue an informational due process, but somehow people and data subjects could co-shape the information flow in that regard. And then here, I think we can also talk about accountability from the practice, from the ground. So there are a lot of interesting movements coming from Latin America, in Brazil in particularly, call it as a citizenship data production. It's called Geração Cidadã de Dados in Portuguese. People are realizing how much data sets are not representativeness of the marginalized people. So they are producing data by themselves in order to send to the state and clearly asking, oh, this database is saying that sanitary infrastructure is covering my area, but in fact, they are not covering in my area. So, for instance, in Brazil, people that are living in favelas are collecting geolocation data plus images to send to the government and say, your database is wrong, so I have to be visible for you in order to enjoy the public policy in that regard. That's an issue of data quality at the end of the day. And they are co-building digital public infrastructures in order to have agency over data, agency over that kind of information flow. The second issue that I'd like to share also somehow a more concrete example, and Bowie highlighted is digital IDs as one of the key digital public infrastructure, mainly digital ID as a foundational ID that is being provided mainly from the government. There, for instance, in Brazil, we are seeing a heavily discussion about what kind of information architecture would be better, a centralized architecture, a decentralized architecture, or a federated architecture. And the Brazilian government is pushing not only to discuss what kind of information architecture would be better, but also from the user-centric perspective would be more accountable in that kind of direction. So now they are developing a second and a third phase of the UX journey of the citizens, mainly in order that they would be aware, would be notified if someone is authenticating those data or not. Because there in Brazil, we are facing a lot of escalation of frauds, for instance. So when people are losing agency and control of over their own information, we are also having not only a problem against the data subject, but also for business at the end of the day. So how we can think about information architecture from the user perspective, and also as an architecture in which they can enjoy those data rights, and then we could see not only accountability mechanisms, but also somehow data justice, as Alison highlighted before, or what we have been called as an informational co-deliberation. It gets a little bit philosophical, but it's important. How, at the end of the day, the combination between DPIs and AI would deliver not only people as being object of information, but also subject of the information. So it's an issue also about agency at the end of the day. Thank you.
Thank you, Bruno. Can you hear me? Well, thank you, Bruno. Now I would like to turn back to the corporate sector, Carmen. Can you tell us in which ways can companies collaborate with governments and other stakeholders to develop digital public infrastructures that balance technological innovation and strong privacy safeguards?
Hello. Yeah. Well, indeed, on collaboration, I was reading just this week some news on DPI becoming a hot topic, not only in the global south, but or in India, Africa, as we are speaking, or Brazil, excuse me, and it's also in Europe. There's these MAPs. There's a report on European technological sovereignty and digital infrastructure, which is due for voting in 2 weeks. And they, the lawmakers, what they want to propose is a strong foundation for DPI. And we transfer connectivity, cloud, software, and AI. And this is really a proposal which builds on the Eurostack industrial policy initiative. What the report says is that the European digital public infrastructure shall be founded on fair and competitive economic models as well as just governance models, where neither private nor companies nor governments maintain centralized control. So I think that this statement really connects with your question about how can private companies such as Microsoft collaborate with government, and also, I mean, just making a note that DPIs may be owned by governments, but also by public-private partnerships. So indeed, one way that can collaborate is by these public-private partnerships. So where both parties can leverage its strengths. So governments will provide the regulatory oversight and funding, and private companies will provide the technology, knowledge, and innovation. It's also important that they align the common goals, so to make sure that there's digital inclusion, there's privacy protection, and there's technological advancement. So another way is, well, we keep talking about, so importantly, inclusive governance. So, and again, as I mentioned, like including stakeholders and making sure that there's broad input from everybody and oversight too. Then something that Boyi was also touching, so that there's a transparent governance structure, so that it allows for public scrutiny and accountability by, for example, making public reports, that there's independent oversight bodies, and that will help in building the trust, which is such an important word. I mean, by oversight, it can also be a court. There's been, for example, a decision in India by the High Court in this important thing of minimization. So the ad hoc on education was really collecting excessive data, and there was a decision in that aspect. Another way to collaborate, or maybe more, I mean, a practice is by the privacy by design. So to apply minimization, which I was saying, encryption and minimization, and also provide user controls, so that the user can really correct, delete, and know exactly which data gets processed by the government, and robust consent management systems. So you control, you choose whether you want or not to provide that data. Another way is the interoperability and open standards that ensure this interoperability between jurisdictions and systems, which facilitates innovation and scalability, and they encourage the development of open source solutions for DPI components. Components is really a concept that builds from the UN framework, which refers to the systems and solutions, and there's a lot of talking about the importance of open source for all that, for governments to share the same source. Then well, really open source, what brings, as we know, is security, is adaptability, and transparency. Well, the capacity building and training, which I mentioned also again, these skilling programs that will not only, train people for the capacity to develop, implement, or manage these DPI systems, digital literacy, and now also AI literacy, and engage with the local communities to ensure that also those in the more marginalized groups get heard. Regulatory compliance too, always compliance with the privacy laws. There's more regulation that would need to be complied, but importantly also privacy laws, and creating frameworks or agreements for cross-border data flows. So it's not just that governments, among them, there may be cross-border flows, but also a citizen that may be located in another jurisdiction. Sustainable development goals, sustainability by meaning digital inclusion and economic growth and social equity, and also environmental impact, making sure that any risks trying to mitigate those by applying sustainable practices. And then in terms of collaboration, I mentioned some examples of successful collaborations in between Microsoft in terms of DPIs, which is Microsoft works with UN agencies. What is one thing? There's an initiative in Africa, which is Earthbound. It's a collaboration with Liquid Intelligent Technologies, which consists in extending internet coverage to rural areas in Africa, because you cannot have DPI without having connectivity, and there's really a need to have internet, high-speed broadband also. Digital agriculture platforms there's another partnership in between Microsoft and OCP Africa to scale digital agriculture platforms, which show how the technology can support local economies and improve public services. And by the way, digital public platforms refers to the exchange of agriculture data by using technology. Then more in terms of digital public goods, Microsoft is a contributor to open source and open data initiatives. For example, it has made platforms and tools available for humanitarian and development initiatives. GitHub is really heavily involved in all this, which supports OpenAI for good. And also in terms of open data commons also, something that will allow researchers to use data. We think that this really contributes to fit into the DPI ecosystem by providing building blocks that governments can use without needing licensing permits. And also, there's some skilling programs too, before more digital, now also an AI skilling, including especially for women or also in the minority groups too. Yeah. Thank you.
Thank you, Carmen. You have enlisted a lot of possibilities, really. Thank you very much. Now, let's dive a little into the topic of harmonization. So, Adeboye, could you tell us what are the challenges and opportunities in harmonizing data governance standards across different jurisdictions? And how does this affect the implementation of digital public infrastructures that uphold fundamental rights?
All right, thank you very much. I think that the subject of harmonization, before going into that, I'd like to talk about how discriminatory data practices may have affected the level at which we can achieve harmonization across jurisdiction. So currently, you probably have heard that the Nigerian government has just fined Meta, and also Brazil at some point also fined Meta. But what is interesting in both cases is that it's for the exact same reason, which has to do with the fact that the regulators in those countries argues that the Meta was treating its citizens differently from how it was treating the citizens in EU. If you look at the data protection or data governance system in these countries, they were modeled after the EU GDPR, right? So it was concerning for those countries that their citizens were being treated differently, especially with respect to data protection systems in terms of the use of WhatsApp in those jurisdictions. Why am I bringing this into the conversation? To kind of highlight some of the challenges to achieving, harmonization in jurisdiction. I will speak to the opportunities that I see, but it is important to also highlight how those kind of experiences affects the argument around having harmonization across jurisdiction. So the example that I give right now, the conversation that is currently happening right now is that the data protection or the data governance system that in the EU is not being properly applied in this jurisdiction. So what I'm saying essentially is that all stakeholders have a responsibility to responsibly adopt the same principles, right? Irrespective of where they are working, right? So if you want to convince, for example, that an African country should adopt what is being applied in the EU, you must also be able to demonstrate that when it comes to the protection of rights of African citizens, you are going to exactly protect the right of African citizens the same way you are protecting the right of EU citizens. So if, for example, Meta protect the right of EU citizens and then comes to Africa and disrespect or disregard the right of Africans, then you want to convince Africa to adopt the same regulations or the same system as the EU. It becomes problematic because of the subject of digital sovereignty. And that is where the clash actually comes from. So we are thinking in terms of sovereignty, at the same time, uniformity in regulation, which is desirable if you think of the digital ecosystem, if you think of the gains of digital public infrastructure, if there is interoperability, if there is clear processes around cross-border data flow, etc. It's good for the ecosystem, but every country is now sensitive. Every jurisdiction is now sensitive because they feel that they are not being treated right, and so they're trying to assert some sort of sovereignty around their data governance system. So I do think that one of the things that needs to be addressed is the issue around discriminatory practices in terms of how citizens of different jurisdictions are treated by data controllers, not just Meta. Unfortunately, I've had to spotlight Meta, but this is not a campaign of calumny against Meta. The next point I'd like to make is that trust deficit has to be addressed. And I think it's very easy to see where the trust deficit is coming from, given the point that I made earlier. But beyond that, there is also a trust deficit between citizens and government, especially in regions with history of data misuse. I come from one of those regions. People don't trust their government. So when government is talking about, for example, harmonizing different data sets or data standard sets, there is usually this paranoid from citizens wondering what exactly government is up to. A clear example, again, biometric data, for example. There was a time in Nigeria where you still have those multiple biometric data sitting in different institutions, and government was at some point trying to harmonize them, because why do you have so many biometric cards? You have your bank card, which is biometric, you have your national identity card, you have your voter's card, so you have multiple cards. And when government tried to harmonize them, citizens didn't trust exactly what government was trying to do, because there has been a history of data abuse, there has been a history of government surveillance, and also general undemocratic practices by some of those governments. So I think this trust deficit needs to also be addressed between the government and the people. But one other key point I also like to make is in terms of the fragmented nature of governance in continents like Africa. So in the EU, it's easy for the EU Parliament to develop standards that, covers the entire EU. It's not that straightforward in Africa. As much as there is the African Union and as much as there are efforts at the level of the African Union to come up with standards, regulation, and all of that, African governments exist in silo. Everybody wants their own rules. Everybody wants to set their own standards. Everybody wants to set their own laws. So it's been quite challenging to get African countries to work together and develop frameworks that are applied across Africa so that it's easy for the private sector, for the companies to even comply with regulations. So if you ask an average company, for example, like the Microsoft, like the Meta, like the Google and all of them, in terms of how they are complying in Africa, they will tell you that that is their biggest headache because you have to comply with 54 different jurisdictions in Africa. And even in each of those jurisdictions, there are multiple agencies coming up with different regulations, there are overlaps, so there is a lot of confusion. So I don't think that one of the challenges in that context is the multiple, the fact that you have to deal with multiple jurisdictions. But I also see an opportunity because the EU, for example, the GIZ, for example, is doing a lot of work in Africa with the African Union, create a data governance framework for Africa. So when you have a data governance framework for Africa, it is easier to have the handshake between Africa and Europe, for example, or Africa and LATAM, Africa and Asia and other parts of the world in a uniform sense. But the other challenge around that is that, again, it is one thing to have the framework, it's another thing for it to be adopted by the African countries. So for that to effectively be relevant, you need each country to adopt it locally, to reflect in their national laws and jurisdiction. But then it creates an advocacy opportunities for those who are working on the issue. When you have like a model law such as the African Union Data Governance Framework, advocates working together with the private sector and other stakeholders can then work in their respective countries to encourage their government to adopt such frameworks so that there is interoperability, there is some sort of uniformity in the governance system in different jurisdictions. That way, the benefits of DPI can be effectively harnessed in many of those countries. But without it, it becomes really problematic. And I don't want to be the guy that talks about all the problem without preferring, solutions. And that's why I'm bringing that up. So harmonization is both a governance challenge. It's also a justice imperative. If we get it right, we can create an ecosystem where digital infrastructure does not fragment or exploit rights, but oppose and amplify them across borders. But don't forget the first point I made, which is the fact that we cannot discriminate in terms of how we treat data subjects in different jurisdictions and then expect support for efforts at harmonization of data governance mechanism. People must feel respected. The people in Africa must feel respected the same way the people in Europe feel. Thank you.
Thank you very much. And to close this second round of discussion, I will go back to you, Dr. Gilwald. And I would like to ask you, are you there? Yeah, thank you. How do we build digital public infrastructures that actively reduce inequality rather than reinforce it? What policy, principles, or institutional arrangements do you see as most effective in promoting equitable inclusion and justice?
Thank you very much. And because we're also running out of time, but also because some of these points have been picked up, I'll just sort of build on some of the points that have been made by pointing out, because we did work very closely with the African Union on it, about the significance of the African Union data policy framework and the absolutely agree significance of harmonization on the continent. Boy's right in the sense that it's just a guideline. Countries in Africa, the African Union doesn't have the same binding treaties, although it has had in the past, and they've taken, like the Malabo Convention, years and years to implement. So I think the pragmatism of moving ahead on this as a guidance to which all countries signed off 2 or 3 years ago now. And as Roy said, with that emphasis on implementation, there's actually been funding for the implementation, which we're doing across several jurisdictions at the moment. But I do think the importance of this, regional solutions where you've got enormous resource constraint and getting harmonization to develop the markets, the economies of scope and scale that you need to run data economies is really important. But let me take a step back and say that, I think the data policy framework is very different from other frameworks, and this is getting to why it potentially can provide the basis for more equitable DPIs. And for the application of AIs and DPIs, and also on their own. So just to emphasize that the data governance framework, the data policy framework for Africa as a governance framework, is a personal and non-personal data framework. And it's very much located in the digital transformation strategy, the African continental free trade area, and the movement towards a single digital market. So in the document, obviously the fundamental human rights imperatives, and one doesn't undermine the importance of privacy and data protection, but this is really only one component. And in the way that it's been practiced through GDPR and various things, it's very much a focus on individualized notions of privacy. And I think what we've done together with other people working in this area about bringing a data justice lens to data and how those protections and things are actually practiced is looking also at collective and systemic harms that emerge from existing data structures and the sort of enormous asymmetries of power that we have between data holders and data subjects. But as I said, very importantly, that the importance of that data, of course, the individual data subject issues and personal data issues, but the real power imbalances come out of the economic application or the extraction of that data for economic market intelligence that's unassailable at the moment in terms of anybody else competing with that. So the heart of the African Union data policy framework is acknowledging the importance of those first generation rights, but also looking at what is being done about second and third generation rights. How are these enabling frameworks, or how are these frameworks enabling of economic rights and of course environmental rights as well? And I think it's that is, it's an extension of some of the social justice work in data protection that is actually in implementation in this policy by looking at questions of economic justice, that you can have, a rights framework that is also a framework that is ethical, but that it may still not produce just outcomes because you haven't actually redressed the inequalities that exist there. So at the heart of the African Union data policy framework is this notion that you don't have to only redress the uneven impacts that Boy's already referred to, in terms of discrimination or exclusion or invisibility, which are of course important, but you also have to redress the unequal or uneven opportunities, economic opportunities that go with the development of these technologies. So in the application to DPI, you need to ensure that citizens, of course, protected by way of safeguards and ensuring that you've got all the benefits of technical standards and stuff, which are all embedded in there. But are you also ensuring that you are regulating data in a way that enables local participation, local competition, local research, local entrepreneurs, local startups, local procurement for those DPIs, and we're not simply getting our DPIs by implementing these massive global monopolies on top of our existing, or on top of already existing privatized infrastructures anyway. So I think the possibility, the importance of this single market, which has an economic imperative, and I think I would say in relation to some of the problems that Boyce correctly highlighted about the fractured nature of previous guidelines, is that there is a very strong economic imperative around this. Unless you get those data frameworks in place, those data guidance frameworks in place, and take the opportunities, for example, of DPIs that can be leveraged to improve not only public sector efficiencies, but also market structuring, that you can get those benefits of cross-border flows. Just to say one more thing about the data policy framework is that in acknowledging the need for economic regulation of data, access to data, quality of data, interoperability, portability of data for labor, for consumers, etc., is that you are creating an environment for greater economic opportunity and greater engagement across the continent, but also that you are able to have a collective weight, both in the, of course, regulation of your markets and your ability to implement and enforce things, but also a greater voice in international frameworks and international governance. So the African Union Data Policy Framework, for example, incorporates a notion of redress and incorporates a notion of preferential regulation, so that we would actually ensure access to public data, private data that's in, maybe in some commons or pool, to local providers. And this might not be indefinitely or whatever, but at a period of time, so that it can't just be scooped up as you open these open data sets by those who've got most resources for it. But we've then gone ahead with the digital protocols in the African Continental Free Trade Area, which is a complete cut and paste from the World Trade Organization. And so we've been unable, of course, that trade always trumps everything else. And sorry, pun was unintended. That you then get a situation where the preferential data regulation that would enable better, fairer competition, opportunity, etc., is not permitted in terms of the trade law, and that's law, and these are guidelines. So I think there's enormous possibility in regionalization, in the sharing of infrastructures, sharing of data, sharing of capabilities and responsibilities, and of course the harmonized benefits of contextualized but harmonized institutional arrangements, because you can only do what you have the capacity to do. But I think the importance of this in the African Union framework is that it does, it does put this into an enabling environment. It does set this rights framework for it, but it also goes beyond what has often been the hallmarks of safe and secure, trusted governance, by saying, this doesn't only depend. If you do data protection, great. If you do cybersecurity, great. That doesn't give you trust, as Paul is pointing out. Doesn't give you trust of big operators. Doesn't give you trust of your governments necessarily. You need a rule of law. You need rule of law. You need to be able to have appeals. You need to have legitimacy of some form, political legitimacy of some form. And I think many people would argue, ideally, a democratic legitimacy, but we've got lots of examples of benign authoritarianism that can also work quite well just from a delivery point of view, although, of course, the issues of rights is a critical one. Thank you.
Perfect. Thank you so much, Dr. Gilwald. And now we have some minutes left, so if you have any questions, please, you can formulate them. Yes, there's one. And if you could please tell us if you want a specific speaker to address your question. Thank you.
Which and the simplification word have been thrown around here in Brussels a lot recently related to GDPR and some doubts on some of the articles' interpretations. From a Microsoft perspective, being a company training AI and that wants to comply with GDPR, which aspects or articles or principles of the GDPR are less clear in the moment how they apply to data sets for AI training?
And maybe before we answer that question, is someone else has? Nonso, please. Also tell us if you want any of the panelists to address your question, please.
Okay, thank you very much for this interesting contribution and discussion. I'm very interested in the enforcement of frameworks, and it would be nice to hear the views of Microsoft on this, since they are the responsible organizations. And I want to know what structures can we incorporate into these frameworks while we are designing them to ensure that we have effective enforcement of frameworks built to design equality and accountability. How can we look towards enforcement of these frameworks even at the guidance drafting stage? So at the end of the day, we don't just have empty frameworks that cannot be enforced. Thank you.
Thank you very much. Someone else with a question? Yeah, there in the back. please.
Hi, my name is Tammy. So Sam Altman said that for AI to blossom, there has to be a rethink of social constructs in society, how we deal with things like data, copyright, etc. I'm wondering what is our opinion on the panel. Do we need to severely reconstruct personal data on public infrastructure or platforms so that we can fully have a blossoming age of AI, or do we stick to our current regulatory structures whilst preventing the next evolution?
Thank you. Okay, so we can start, Carmen, maybe addressing the questions. Thank you.
Okay, it's working, yes. Well, your question is on the AI training and data sets for that and principles from the GDPR. Well, it's true that it's really the GDPR that we would get more information than, for example, Brazil, that because we are talking about Brazil, I bring Brazil. We're still waiting for an AI consultation indeed in Brazil to clarify more. In Europe, we've had, well, in addition to the GDPR, of course, an opinion from the European Data Protection Board from last December, clarifying on the aspects of data processing in the development and deployment of AI systems. Well, it's something really that Bruno touched on the training. It's important transparency. That is a clear principle. And, well, it's also where you will train, you will do so as a data controller. And you will, of course, need to be transparent and disclose information on how you use, how you collect, how you delete. So that principles are important and would be normally disclosed in your privacy policy. The one aspect that I think is more unclear is the legal basis, because in order to show accountability, you have to have a lawful basis for processing any personal data that may or may not be part of those data sets. So, I mean, this opinion acknowledge and also by fostering innovation, the possibility to rely on legitimate interests, and there's lots of maze, but they give a lot of importance to the mitigating measures. So one measure is mitigating is the transparency by allowing the data subject, the citizen, to have that information. But I mean, there's other filters. There's also, red teaming testing. There's a lot of examples that were given. And the bell was a bit disrupting. Yeah, I mean, you talk about principles, and I think, yes, it's, they talk about the not only compliance with GDPR, but the GDPR plus compliance, which is required, and that includes these examples in terms of mitigating measures that it would be good to know more information on, depending on which supervisory authority within Europe, what will be the views on which mitigating measures would be more suitable. And as we always say in data protection, I mean, depends on the context too. The context is very important. Thank you.
Just a few words about the enforcement. I think there are, anyway, like if you establish a comparison between the capacity of the regulators here in Europe, according to different countries, but also in comparison to Latin countries and others, there is a gap between them in terms of capacity. So that's why, at least in Latin countries, and we can see this heavily happen in Brazil, we can think about a network enforcement. So the regulator is not only the data protection authorities, but also the civil society, also academia, when they are producing evidence to make the case even more successful. So, for instance, the big case that we have in Brazil is going to be analyzed by the judiciary. not only on the administrative level. So you can think about not only the regulators in a plural way, in a diverse way, but also different layers that are complementing each other. And then I think the final result, the balances, might be positive in that regard.
Okay, do we have more questions? Yeah, one more?
Could I just come in on the question around regulation?
Yeah, there is, oh yeah, Timmy's question. Timmy, do you want someone from the panelists to address it, whoever? Yeah?
I think that's the question about whether we should pause to address social contracts, right? Yeah, I do think this particular conversation came up in one of the sessions I attended earlier today, and one question that popped up in response to that was that even if we say we should do that, how do you ensure compliance? And from business perspective, what then happens is that some people comply, some don't comply, then there is then unfair advantage. Let's look at the the development of nuclear energy or nuclear weapons. For example, the UN has come to many resolutions asking nations to stop developing nuclear weapons and stuff like that. Some comply, some don't comply. Those who don't comply then get competitive advantage over those who comply. The real point I'm trying to land on is to say that I really don't think it's practical. It's on paper, it looks great on paper, but in reality, I think we have to think in terms of learning by doing. We have to just continue to try to figure things out as we do. We have to learn by experience. I don't think that, putting a stop to the process will in any way give us the outcome that we want. Because number one, it is not even realistic to put a stop, because if you say we should put a stop, some people will stop and some will not stop. So I do think that we just have to embrace the complexity and the confusion that comes with trying to figure out how best to regulate, how best to achieve the best outcomes that are, that promotes the most equitable, the most inclusive, the most beneficial social contract, while at the same time dealing with the different complexity and the challenges of regulations that we have to deal with.
Okay, thank you very much. Sadly, we've come to the end of this panel, and we don't have much more time, so I think to please give a round of applause for the speakers. And thank you so much once again for joining us today.